Being a leader comes with challenges. The Leading to Win podcast will help leaders make wise decisions by leading to win. Here's your host, Marty Haynes.
Welcome to Leading to Win, where our goal is to help you become a better leader. And today I have Joanie Winters with us from Winters Law Firm. And we're going to definitely educate you on some things today. And Joanie, I appreciate you taking the time today to educate us on mandatory employer COVID testing and vaccines. I'm looking forward to where this is going to go because, you know, we all need to know this because our clients are asking. And I know you're gonna tell us some things today.
Thank you, Marty. We've been talking about COVID for almost a year now, and every time we talk, it's about something different. So today, we're going to talk about what employers can do and what they can't do as far as testing and vaccines. As everyone knows, the vaccines are starting to be rolled out for first responders, folks that are in adult care, and then those that are over 70, and then the governor dropped the age to 65 the other day. I personally got my first shot thanks to our local EMS because they had shots left over. So for those who don't know, these shots have to be kept very, very cold. And once they're out of refrigeration, they have to be used. So sometimes the local immunization agency will call around and say, is there anybody who needs a shot? So I was fortunate enough to get my first shot. But it really triggered the thought for me as an employment attorney. What are our employers doing? Are they mandating vaccines? Are they mandating testing? And do they know what they can do and not? And so that's what we're talking about today. And the answer to both is yes. But of course, from a legal perspective, there are always caveats and concerns for employers. So let's look at testing. Employers can absolutely test, and many of us should, depending on what our business is. So if you have a high profile business with the public, you should be requiring your employees to get tested. Now, I can tell you that here in Chester County, our EMS is giving away test kits. They are delivering them to local industry. So the industry just needs to call them and say, this is how many we need. And the EMS guys will take it out to the plant or the business. They are spit tests. You spit in the tube, you mail it away through FedEx, it comes back online for you in an email 48 hours later. So they're very quick, very rapid, and they're free. Check with your EMS in Lancaster County, York County. I don't know what other counties are doing, but if those tests are out there and they're available for you as a business, I would get them just to have them on site. So you can require testing. You want to be careful with the test results. These are HIPAA protected.
Right.
The results, and so you want to make sure they don't go in the general personnel file. If you have someone who comes back positive, you cannot talk about it. You can't tell other employees that Joe has tested positive. You do have to do some contact tracing and let everybody who may have had contact 15 minutes or more, less than 6 feet with Joe, but you cannot tell the employees that it was Joe. And I get questioned all the time by employers. Well, we're a small shop. Everybody's going to know it's Joe. Well, that's fine. Let everybody surmise what they may, but you cannot tell your other employees. You can just tell them they may have been exposed and let's get you tested. You can test employees who come in the door. Maybe they've been furloughed, maybe whatever. You can test them as they're entering your workplace. You can do temp testing every time somebody walks in the door. If you're keeping a log of those temp tests, make sure that, again, you treat that as a HIPAA document.
Right.
You can have a questionnaire. I don't know that I've been anywhere in the last 6 months that is not my own building where I've not had to complete a questionnaire of where I've been in the last 2 weeks. Do I have COVID symptoms, things like that? Again, HIPAA documents. So it's not a bad idea to have your employees complete that maybe once a week. That's up to you. What you cannot do is require an employee who 100% works from home. You cannot require them to get tested because the reason you can test your employees is the EEOC has decided that COVID creates a direct threat to either the employee or others. Well, if your employee is working at home 100%, there's no direct threat.
Right.
They haven't exposed anybody, nor have they exposed themselves. So don't do it with those who are working at home unless and until they come back to the workplace. So when they come walking in the door, they're back at work full time or maybe even part time on site, you can then test them, but not as they're working at home. So that's testing. Now, if you have someone who says, I have a religious objection or I have a medical condition, you can, as an employer, require some type of documentation to support that. So let's look at a religious request. Who do you get something from? You don't get it from a doctor, but you can get it from the leader of the spiritual group. You can get it from the pastor or the priest or whomever that may be, that Joe Smith cannot get tested. It's against the faith. It can't be just because. It can't be because I'm scared, and it can't be because I don't trust the test. Right? It has to be a bona fide reason. So that's testing. Vaccines, same thing, pretty much the same argument. Now, vaccines, you have to be very careful because if someone does have a religious exemption or a medical, you have to respect that. You don't have to like it, but you have to respect it. And you can require that employee to be out of the workplace. So you can require them to work at home or to work somewhere else because of that reason, but you can't fire them. I want everybody to be very clear on that. You cannot fire someone for refusing a vaccine. If you require them, make sure that you have a business necessity reason, okay? And the direct threat is a business necessity reason. But you may have to justify that if you get a legal challenge, if you get an OSHA challenge. Again, from an employer standpoint, your response can't be just because. You're going to have a really good, valid reason. So let's say I refuse both the test and the vaccine because of health reasons. I have COPD or I have whatever, and I'm afraid I usually react to flu shots with severe reactions. And so I come to you and say, Marty, I'm not going to take the vaccine because I am prone to anaphylactic shock. And so you're going to say to me, okay, that's great. Get me something from your medical provider and let's see what we can do to help you with some reasonable accommodation. Can we have you telework? Can we have you work in an isolated office where you're not subject to a direct threat to either yourself or others? You as the employer must work through this interactive process. And I would strongly recommend if you do that, you document everything you do, log your activity, because if you do get a challenge, there's your defense, that log. You can show to OSHA or you can show to the EEOC, we did engage in the interactive process. The employee didn't want any other reasonable accommodation other than what they asked for. But we offered many options and the employee refused all of those options because the employee has an obligation to engage also.
Yeah. Now you may touch on some of this. A couple of things come to my ignorant mind because I'm not a lawyer. One thing is, what about, you touched on the safety and somebody having those kind of issues. What happens to the liability side when, you require somebody to come in and get vaccinated and they have some horrible allergic reaction to the thing. And they say, hey, my employer gave it to me, XYZ. I'm sure that those things will happen.
They will, and that's a great question for you and I who live in the world of trying to prevent liability for our clients, or at least cover the liability as best we can. It's an issue. It's an issue that doesn't have a clear answer either. The new stimulus COVID package, I'm not even sure what to call it, that Washington is kicking around right now, has some language in it that does protect employers from liability. I think I've shared with you that the package itself is about 7,800 pages. I'm only up to page 5,200 or something like that. So I'm still not completely through it, but there is a little bit of language in there that they're trying to assist employers in not having liability that we have no control over. So if we bring in a Pfizer vaccine and we have our medical provider come in and administer that, we shouldn't be held liable for that. Now, if an employee comes to us and says, I do have a medical condition, I can't take this, we're aware of that. If we force that employee to take the vaccine after being aware of a medical condition, now we have strict liability.
Right. Okay.
But if we're bringing in the local urgent care or the local EMS to provide that questionnaire that I mentioned earlier should also have a consent line on it where the employee signs off, understanding that the local EMS or whomever is administering the shot is not a member of Haynesville Circle benefit. It is someone third party, and we are not responsible for that shot. So I would have some indemnification language on that consent form.
Okay. And you also mentioned constitutionally, you mentioned religion, and this may be totally off topic somewhat. But what if, today, somebody's coming in and going, look, I'm not going to use religion. I'm not going to use this. I just don't think an employer constitutionally can make me do X, Y, Z. Is that where you just basically at that moment are document? So if OSHA or something else happens, you say, look, here's what we did. Here's the scenario.
Great question. And just to go back to, I guess, high school for a moment. So the Constitution was written to protect us from government. It was not written to protect us from private sector. And so unless your employer is the government, whether it's county, local, or whatever, there's no constitutional protection. And so OSHA and the EEOC have gotten together. They're supposed to issue guidelines. They have not yet, but they have issued the edict that they are not considering requiring vaccines or requiring testing to be a violation of either OSHA regulations or EEOC laws, meaning Title VII of the Civil Rights Act. So they have both sanctioned testing and vaccines as long as we don't have the medical question or the religion question.
Okay.
Now, there is a third caveat there, and that is if you are a union organization and you have a collective bargaining agreement. So the CBA is the agreement between the company and the union. The CBA contains all the terms and conditions of employment for the union workers. When you require testing and or vaccines, you're changing the working conditions. You're changing the terms of employment. And so that means you have to go back to the bargaining table. So if you are under a CBA, don't just infuse testing or vaccinations because you will get in trouble with your union. You'll get an unfair labor practice charge.
Yeah. Now this is really backing up a little bit. And sometimes I know when I ask off the cuff questions like this, you're going like, oh goodness, tell him what he's going to ask me. But when you mentioned earlier, and I mentioned the question about constitutionally, and you said against our employer, all right, what about the city municipalities in the area? Are they affected in any way differently?
Well, they are. If you mean the city as an employer, that's one thing, or the city as requiring masks, things like that. There could be an argument that it's unconstitutional for a municipality or a county to require masks in the streets. In their own buildings, I don't believe that's unconstitutional. That's their building. And again, they're worrying about direct threat and public safety and all of that. So I think there's a strong argument for them to be able to do that. As an employer, the city of Lancaster, I think that, there's a constitutional argument, but I think it can be defeated because, again, we've got two federal behemoths, OSHA and the EEOC, who have said this is okay. We've looked at this, and it's in direct correlation with direct threat. So it's public safety. I think DHEC would back the county or the city. So I know that there are some folks that feel that maybe their constitutional rights have been trampled. We're in a really unique situation, and I think those arguments would be defeated or could be defeated.
So you think basically if an employee there, the city or the county or whomever, whatever county we're dealing with, even though it's a government entity, an employee says, look, I'm not using religion, but I just think it's unconstitutional to make me do this. You don't think that employee would, even though they're employed by a government, will not have a leg to stand on?
I don't want to say that as strongly as they won't have a leg to stand on. I think that I serve as the county attorney for Chester County, and one of the things that we as county attorneys have done is we have asked the Attorney General to weigh in on that and give us some guidance, because we really don't know. I don't know how a federal court judge would rule on that question. I think, though, that there is a strong argument for public safety, employee safety. Whether it would unequivocally prevail, I don't know.
Right. Okay. Well, we have you and I have a wide range of clientele, and not all of them are private sector. Some government sector, and you just try to keep the whole thing in your head, because everybody's going to be a little bit different in what we're dealing with.
And I will tell you, Marty, I would equate it with the argument, and I get this a lot, social media. Employees in the private sector have different rules for posting to social media than employees who work in the public sector. But does that mean that employees in the public sector can say whatever they want on Facebook? It does not. They're under the Constitution, whereas private sector is not. And I look at these two issues with testing and vaccines the same way.
Okay, makes sense, because I'll get the questions, and
yes.
Well, let me kind of go that way. All right. Well, good deal. Well, this was some very informative information and questions that we get. Is there anything before we end that kind of maybe summarize something we didn't touch that you want to just sum this up with?
I would just, as an employer, whether you're public sector, private sector, or even nonprofit, I would proceed with caution and definitely speak with your legal counsel before you create any kind of program. But I would create a program. I would not be doing this by the seat of your pants, because this is something that will spawn litigation. There's no doubt in my mind. And if you've thought things through and you have a good policy and you have a good program put together, you'll have a stronger argument than if you just decided on the spur of the moment to start testing people and vaccinations and things like that.
Okay. All right. Well, good deal. Like I said, very good topic today. And Joanie, again, really appreciate you taking the time today to be on Leading to Win.
Always a pleasure. Thank you, Marty.
All right. Good deal. Thank you, Joanie. And everybody else, thank you as well. Appreciate you watching today, Leading to Win. We hope you have a good day. Y'all take care.